We're with David Shapiro. David is a criminal lawyer in San Diego, California, and has agreed to answer some online questions specifically related to assault and battery. David, with that said, the first question that was posted, question was posted by Miles. I guess straightforward question. Have you ever represented clients charged with assault?
Yes, Miles, I have tens, if not hundreds of times.
Okay, next question was Harvey. What's the difference between a misdemeanor assault and a felony assault?
Well, there's a couple of differences. A lot of times misdemeanor assaults and felony assaults are charged under the same code section, under the same penal code section, usually penal code section 245, whether it's A1, A4, somewhere in between there. And it could be charged as felonies or misdemeanors, like I said. If it involves a weapon, it can still be charged as a misdemeanor. Depending on the weapon, depending on the injury, depending on your prior criminal history, that's a factor that'll change whether or not the case is filed and charged as a misdemeanor or as a felony. If it's assault by means of force likely to cause great bodily injury, same type of thing. If it's a fist fight and there's a brawl and there's punches thrown, what's the extent of the injury? What's your prior criminal history? Were you justified? Was it a self-defense claim that might have gone too far, or was it where you were the aggressor? All those factors go into it. Usually what I see as the main issue is the weapon, if it involves a weapon, and the extent of the injury, if in fact there were injuries or the possibility for injuries.
Okay, the next question we had, this kind of touches on what you just mentioned, but Adam says, what is assault with bodily injury enhanced in assault and battery charge?
Well, if you're referring to the enhancement, Adam, it could be if someone's injured and it's deemed great bodily injury, that could basically turn, even as a felony assault, could turn a felony assault into a strike felony assault, which would make it a serious felony of personal use of basically personally inflicted great bodily injury, and then would turn it into a violent strike felony if you did in fact induce or cause great bodily injury. So that's the main thing. Great bodily injury would up the ante, so to speak, because it would turn a felony assault by means of force likely to cause great bodily injury, which has a 4-year maximum, into a 7-year maximum. If someone has GBI or great bodily injury alleged, it would add 3 years on your possible exposure. So it definitely makes the case considerably more serious, and also in almost every instance, in fact, in every instance, will convert a non-strike felony into a strike felony, which will affect custody credits if, in fact, you do get sent to custody. Will affect basically the rest of your life as far as any future contacts you have with the criminal justice system, as well as any background checks moving forward.
All right. And second to last question was, what do you have to show in order to establish a defense based on self-defense?
Well, in order to establish a defense based on self-defense, it's one of the few affirmative defenses where you, as the accused, would actually need to, put forth some evidence here. It's usually the other way around. But in self-defense, you would need to show that you felt, or you were in a situation, very generally speaking, where you felt you or someone, if you're defense of others, was in harm by use of force by somebody else, and that your actions were the least restrictive, or basically the most reasonable means to prevent that. And there was no other way to do it except for the way you did, and the force that you used did not exceed what was reasonable and necessary to basically turn away the other force. Okay, so there's all those factors that go into it. Problem we see a lot of times with self-defense is people go too far. Or if it's a defense of others, they can say, yeah, I was defending my brother. It's like, yeah, but that was for a fight that happened a week ago, not right then and there. So that's usually a big problem we see with self-defense claims. In other instances, it may be the only defense you have.
Understand. Okay, and the last question we have here is from Charlie. Charlie said, can I be convicted of assault where there was no physical contact between me and the other person?
Yes, you can, Charlie. And the greatest example would be if you were to throw something at somebody and, excuse me, and you throw something at somebody, you're assaulting them, you don't actually have physical contact with them. Another example would be if you're involved in a situation where you're an aider and abetter, where you're charged for aiding and abetting the substantive crime, or basically if you're an accomplice. Say, you and your friend are at a situation where, he's attacking somebody and you're sort of there and not doing anything to prevent an attack, and you're not hitting himself, but you're sort of cheering your friend on. I've seen people charged and I've seen people convicted of that. So it certainly looks a lot worse if you're the one actually inflicting the force, but you can be charged and you can unfortunately be convicted, even if you don't make physical contact with the person.
All right. Well, if you have any other questions for David, just feel free to post them in the comments section below. He's agreed to answer any questions you have online. With that said, thanks for your time, David.
Yeah, my pleasure. Again, I can be reached at my office, 619-295-3555.